This information in this blog post is provided for general informational purposes only and may not reflect the current law in your jurisdiction. No information contained in this post should be construed as legal advice from Pat's Answers Archives or the individual author, nor is it intended to be a substitute for legal counsel on any subject matter. It's human nature to avoid thinking about and planning for your possible demise. But now that we're into 2021, having faced in some instances overwhelming medical challenges, it would be prudent to consider a durable power of attorney for finance. In a previous video post, we discussed the durable power of attorney for healthcare and the reasons for having one. In today's episode, we will discuss the durable power of attorney for finance. Your bills and financial obligations do not stop, even if you become incapacitated, so that you cannot conduct your affairs personally. A durable power of attorney form is used to allow a representative, known as the attorney-in-fact, to act on behalf of another individual, you, the principal, in financial matters such as running your business, signing legal documents, paying bills, filing taxes, and managing assets. Usually a spouse, relative, or close friend is chosen to be the principal's attorney-in-fact. In Missouri, the agreement becomes void upon divorce if a spouse is chosen. Therefore, a secondary agent should be named to ensure that the principal's interests will be represented in the event of their incapacitation and in the event of the incapacitation or inability to serve by the principal agent. In many states, Missouri being one of them, it's not a legal requirement to have an advance directive drawn up by an attorney. That does not mean to imply that you should do it yourself, as having competent legal advice is always a prudent thing to do. There is an online resource that you can use to draw up your own durable power of attorney for finances, and it is a tool that you can use for the purpose of preparing the document as you want it, even if you will be using the services of an attorney. It will help you to make certain that you've crossed all the T's and dotted all the I's and followed the law in your jurisdiction. That online resource can be found at the following web address. We will click on the link and go through the form step by step after this message. We will return to our program after these words. It is important to understand that the Constitution does not create rights for anyone. It simply serves as a grant of power to and a blueprint for the structure of the federal government. The rights of the people existed before the founding of the United States. You do not have constitutional rights. You just have rights. To protect them, you must understand them. The book, A Republic If You Can Keep It, can help you with that understanding. Available at patsanswers.com/blog. Click on the Store tab. $16.95 plus shipping and handling. All major credit cards are accepted. Buy it today. This is the Missouri Durable Financial Power of Attorney. First thing that you have to do is put in the name of the principal, first name, last name. The principal is also the person known as the person giving the financial power to someone else. Principal's address, next page. Now, who's receiving the power to act? That's the agent or attorney-in-fact. Next page. Does the principal want to elect a second agent? Usually you would say yes. In this case, for speed, we'll say no. Next page. Will the agent have the right to access the principal's bank accounts? In this case, yes. Next page. Will the agent have the power to pay and file taxes? In this case, yes. Next page. Will the agent be able to have access to any safety deposit boxes? Again, yes. Next page. Will the agent be able to make loans, promissory notes, or borrow money on the principal's behalf? Again, yes. Next page. Will the agent have power over government benefits? Again, yes. Next page. Will the agent have the power of principal's retirement plans? Again, yes. Next page. Will the agent have power over the principal's real estate holdings? Again, yes. Next page. Will the agent be able to buy or sell personal property? Again, yes. Next page. Will the agent have the power to buy, sell, or exchange stocks and bonds? Again, yes. Next page. Will the agent have the power to handle the principal's commodities and options? Most people don't have them, but if they do, yes. Next page. Will the agent have the power to make gifts? Again, yes. Next page. Will the agent have power over the principal's business, if any? Again, on this case, yes. Next page. Will the agent have power over any insurance policies or annuities? In this case, yes. Next page. Will the agent have power over the principal's estates, trusts, and other beneficial interests? In this case, yes. Next page. Will the agent have powers over claims and litigation? In this case, yes. Next page. Will the agent have power to assist with the principal's family obligations? This one's important, especially if there are any young children receiving child support or if a member of the family is receiving financial assistance. In this case, yes. Next page. Will there be any additional powers or special instructions given to the agent? That's up to you. In this case, no. Next page. When will this power of attorney begin? Immediately or upon incapacitation? Under normal circumstances, you would put it upon incapacitation, unless there's a particular reason to have it start immediately. In this case, upon incapacitation. Next page. Will the agent be reimbursed for any expenses that occur during times as the agent? Normally you would say yes, because you don't want your agent to be out of pocket when they're doing a job for you. Will the agent be entitled to reasonable compensation for their duties? Normally, unless you're hiring an attorney or a trust officer, you would say no. Next page. Does the principal agree to have this power of attorney signed in front of a notary public? In the state of Missouri, that's a requirement. So in this case, yes. And we'll hit save. And it's saving. And what you end up with is your durable power of attorney for finances, all filled out with the principal's name, the designated agent's name, their address, and so forth. They are not appointing an alternate agent. And then you've got places where, like, they delegate the following powers. Banking, there's a space you have to initial. And all the way down the line, business interest initial, safe deposit box initial, stocks and bonds initial, commodities and options, you initial, like here, claims and litigation, you would initial, lending and borrowing, you would initial, government benefits, you would initial, retirement plans, taxes, insurance and annuities, estates, trusts, and beneficial interests, real estate, personal property, whether or not you can sell it or dispose of it, all under the auspices of this durable power, personal and family maintenance, paying of child support or other support, gifts, whether or not you're authorizing gifts, special instructions. If there are no special instructions, this would be just initialed. If there are special instructions, they would go in here. The effective date, In this case, it's when the principal's attending physician says that you are incapacitated, and that needs to be initialed. This talks about the authority of your agent, the liability or lack of liability that the agent shall incur, reimbursement and compensation. This paragraph says that you can amend or revoke this as principal at any time, as long as you are mentally capable of doing so. This paragraph states that the power of attorney is governed under the laws of the state of Missouri. This paragraph says that photocopies of the document can be relied on as though they were originals. And then here you have a place for date, the principal's signature, the agent's signature, and finally this needs to be signed in front of a notary by both the principal and the agent. Be the state of Missouri, in our case Taney County, the date, notary public signature, date that the commission expires, and they would put their notary seal there. This is the entire 13 pages of the durable power of attorney for finances in this particular case.